Okay, we're going to talk about the case of Manning versus Vellardita. It's a very recent decision from the Delaware Court of Chancery, and it dealt with the issue that should be of great interest to the legions of attorneys from outside of Delaware who come to Delaware to litigate and are admitted pro hoc vice for purposes of the individual case that they're involved in. And this is a decision that dealt with the problem that occurred when one of the attorneys from New York who was admitted pro hoc vice did not disclose his affiliation with one of the firms that was involved with the company that was in the case. It was a Section 225 case which involves a dispute about who validly holds board of director positions. And in order to make that determination, the court had to analyze a transaction and involve the issuance of shares and the use of those shares as collateral. And one of the lawyers for the company was in a firm called Shibboleth, and one of the attorneys admitted pro hoc vice for the plaintiffs was the head of litigation for that firm, but in his motion for admission pro hoc vice, he did not disclose that. He identified himself as being affiliated with another firm. So those sounds like those facts are somewhat egregious, but there are several important principles from this case that I think have much broader application beyond the somewhat unusual facts of this case. And those several principles are that this court opinion made it clear in a way that has never been articulated before that when you're filing a motion for admission pro hoc vice, you have a duty of candor to fully disclose to the court any material facts that might create a conflict or might arguably be subject to a conflict of interest analysis. And conflicts of interest are very nuanced, and reasonable people often differ whether there is a conflict. But the point is that if there is any argument to be made, then when you're doing a motion pro hoc vice, you have to disclose it. And the other important principles are some that are not new but are worth repeating. The court expressed its acknowledgement, its awareness that motions to disqualify are often used for less than noble purposes or less than noble reasons. And so in this case, because of that issue, conflict with the attorney who moved for his pro hoc vice admission, the other side wanted him to be disqualified, number one, and wanted to have the motion pro hoc vice revoked, wanted to have the grant of admission pro hoc vice revoked. And the court said it wasn't going to do that because it didn't reach the threshold of interfering with the efficient administration of justice. But because the court wanted to send a message that it was not going to condone that type of behavior, it took the somewhat extraordinary step of referring the matter to both the Office of Disciplinary Counsel in Delaware, which enforces violations of legal ethics, and since this attorney was from New York, the court was going to refer it to the arm of the courts in the state of New York that dealt with the enforcement of legal ethics violations. So for those reasons, it's a noteworthy decision that should be of great interest to not just Delaware attorneys, but the many attorneys around the country who often come to Delaware to litigate and enjoy our southern hospitality.